नमस्कार, मैं एडवोकेट अभिषेक रंजन सिंह। केस नंबर 7, विजेंद्र सिंह वर्सेस यूनियन ऑफ इंडिया एंड अदर्स। जैसे जैसे हम आगे बढ़ रहे हैं तो आपको भी क्लैरिटी आती जा रही होगी कि किस तरीके से जो इंडियन कोर्ट्स हैं, पर्टिकुलरली सुप्रीम कोर्ट है, वो बहुत लिबरल व्यू ले दे रहा है डिसेबिलिटी पेंशन का स्पेशली, एंड राइट सो उनको लेना भी चाहिए उस तरीके से। बट जब कुछ ऑफिस मेमोरेंडम्स आते हैं, ऑफिस ऑर्डर्स आते हैं, कुछ ऐसे एक्ट्स बीच में आते हैं तो कंफ्यूजन क्रिएट करते हैं। और जो अभी हम केस देख रहे हैं, विजेंद्र सिंह वर्सेस यूनियन ऑफ इंडिया एंड अदर्स, कहीं ना कहीं ये कंसोलिडेशन है जो धर्मवीर सिंह से शुरू हुआ, सुखविंदर सिंह, राम अवतार होते हुए केजीएस भुट्टर एंड अदर्स, इन सब में आया। तो इस पर्टिकुलर केस में जो, जैसा कि मैंने बताया था कि इफ द डिसेबिलिटी कंपोनेंट इज लेस देन 20%, इट इज नॉट कंसिडर्ड attributable to or aggravated by the military service. So जो सर्विस एलिमेंट का कंपोनेंट है पेंशन में वो तो दे दिया जाता है, बट जो डिसेबिलिटी एलिमेंट है वो नहीं दिया जाता इफ इट इज नॉट 20%, विच इज स्ट्रेंज बिकॉज हमने जैसा पहले डिस्कस किया था कि द मोमेंट यू आर रिक्रूटमेंट, आप एक मेडिकल फॉर्म भरते हैं एंड मेडिकल फॉर्म में क्या आता है, यू आर फिजिकली एंड मेडिकली फिट। देन व्हेन वंस यू एंटर द सर्विस, देन व्हाट हैपेंस? नाउ देर आर सिचुएशन, जैसे अब हम केसेस देखते हैं, मैं आईएफटी में देख रहा हूँ, हाई कोर्ट्स में देख रहा हूँ, देर आर सम लाइफस्टाइल डिजीजेस जो आते हैं। नाउ दैट इज द सोल रिस्पॉन्सिबिलिटी ऑफ द इंडिविजुअल। नाउ इट इज अ ट्रिकी सिचुएशन प्रूव कर पाना बिकॉज ऑफ योर हैबिट्स यू कॉन्टैक्टेड दिस, और द कंडीशन इन विच यू वेर पोस्टेड, बिकॉज ऑफ दैट इट हैपेंड। तो कहीं ना कहीं ये तो मेडिकल बोर्ड ही डिसाइड करेगा बिकॉज देर आर साइंटिफिक इंस्ट्रूमेंट्स एंड देर आर साइंटिफिक टेक्नोलॉजीज अवेलेबल जो ये डिसाइड करती हैं। बट courts have been taking a liberal view once you go to them, and Bijender Singh वाला जो केस है बहुत लेटेस्ट केस है 2025 का, where this rounding of broadbanding was consolidated, and it is kind of restatement of all the cases which we have done till now. Now in this particular case क्या हुआ मैं आपको बताता हूँ। He joined this Bijender Singh. He joined. He was enrolled on 30th September 1985. He was posted to Siachen Glacier between May 1988 to 20th September 1988. So in October 1988, he developed a generalized tonic clonic seizure. So in short, he developed a seizure disorder, but his disability was assessed at 15%, and he was invalidated out by a invalidated medical board dated 89, which wrote in his medical report that it is not attributable to the service condition or aggravated by the service condition. Now, he approached the courts. There he was denied the relief. He approached the High Court. At that time, it was denied. And then he approached the AFTs after AFT was formed. There also it was denied. Now, the arguments जो इसमें आए वो मैं आपको पढ़ के सुनाऊंगा. Both the tribunals 2016 and 18 were unsustainable in law. The tribunal orders were unsustainable in law. The review had been dismissed mechanically for no error apparent, ignoring that a coordinate bench with a common member had granted pension to a similarly placed applicant in Mehal Singh in 2014. That is very unfortunate. You see, उस बेंच पे जो एक जज साहब बैठे हुए थे उन्होंने इसी तरीके की एक पिटीशन में रिलीफ ग्रांट की थी, बट व्हेन ही इज सिटिंग इन अनदर बेंच नहीं दिया, एंड that is what was put forward by Bijender Singh. Point number 2. The order dated 26 January 2016 was a contrary to binding precedent in Dharamveer Singh that I have already discussed, in Rajbir Singh versus Union of India and Union of India versus Angad Singh Titar. But the case has already been decided, तो आप मुझे क्यों नहीं दे रहे हो? Point number 2. A disease leading to discharge is deemed to have been arisen in service if no note of it existed at entry. As I have mentioned, अगर एंट्री के टाइम पे जब there was no mention of disease, that then in that case it must be attributed to the service condition in which you are. The tribunal never considered whether the disease was attributable to or aggravated by service, focusing solely on the 20% itself an error apparent on the face of the record. The tribunal overlooked the instruction dated 31st January 2001 rounding off of disability below 50% to 50% and 20% minimum was abrogated with effect from 1st January 1996. It is unfortunate that in spite of letter dated 31st January 2001, he was not granted relief. Now, what the Union of India said, the Union of India, the respondents, they said the applicant's case was duly considered. Since his disability was less than 20%, he could not be granted disability element, and that was rejected. The appellant ought to have preferred an appeal to the appellate authority within the specified period. Instead, he submitted a representation with the Ministry of Defense, rejected after consideration in the light of the relevant rules. And the third was disability or the disease was assessed by the medical board was neither attributable to nor aggravated by military service, so it was devoid of merit. This was the contention of Union of India. Now ये तो हम पहले से ही पढ़ के आ रहे हैं धर्मवीर सिंह की केस में भी कि at the time of enrollment if it was not mentioned in the medical book then it must be considered that it has arisen because of the service condition or aggravated by the service condition. कई हवाला दिया गया उन्होंने रेगुलेशन 173 का, रेगुलेशन 183 का, but the relief was not granted in the earliest. Now the judgment, the most important part, and what the judgment said. The tribunal merely relied on the invalidated medical board, resurvey medical board, that the disability was below 20% and never examined whether disability was attributable to or aggravated by medical service, the core issue. Now, they gave a percentage, but not the reason for that. Why it was for 15% or 20%, but जो मेन कंपोनेंट होता है एग्रीवेटेड बाय एट्रीब्यूटेबल टू वो कभी इनवैलिडेटेड मेडिकल बोर्ड में भी नहीं आया और रिसर्वे मेडिकल बोर्ड में भी नहीं आया. तो जजमेंट जो सुप्रीम कोर्ट का है दैट इज वेरी इंपॉर्टेंट बिकॉज वो बहुत क्लियरली इस चीज को बोल रहा है कि आपने क्लैरिफाई तो किया ही नहीं द रीजन फॉर इट, यू जस्ट गिव इट अ नंबर 12%, 13%, 14%, 18%, whatever it is, neither explaining the reason for it. Now, neither the IMB, the invalidating medical board, or the resurvey medical board stated the disease could not have been detected at entry, nor the contrary. Invalidated medical board categorically recorded that no disability existed before entering the service. तो दोनों चीजों को ही आपने ओपन रखा, बताया भी नहीं कि एंट्री से पहले इनको ये डिजीज थी. The law is crystallized where there is no note at the entry, the member suffered from the particular disease. The presumption is that the disease was contracted because of military service, and the burden of proof is it is neither attributable to nor aggravated by service rests entirely on the employer, that is Union of India, the armed forces. Any disease, disability, or which a member is invalidated must be assumed to be above 20% and attracts 50% disability pension following the Sukhwinder Singh case, and disability pension being a beneficial provision must be construed liberally. Now, what this means? This means that at the time of the entry enrollment, there was no mention of any disease, so it will be on the employer, not on the employee, to prove that it is not attributable to military service. So, ये तो clear हो गया. Now it is justice in rem. It is a self explanatory, and the legal position is established in this case. So there was no question of not granting him the disability pension. And a rounding off as per the 2001 letter, it is clear. So the petition of the Union of India was rejected outrightly, and he was given the relief. So as we see, the military jurisprudence or the pension jurisprudence in this, it has to be taken into a liberal view. बहुत difficult condition में ये काम करते हैं, and that has to be taken into account. Now, there are scientific methods of assessing whether it was because of military service or not military service, but once a person has become disabled and he has served the motherland, there must be some relief, and the due which he truly deserve must be granted without any hassle. So I believe it sums up the disability element, whether attributable to, aggravated by, rounding off, broad banding, regulation 173 makes clear कि क्या होता है, कट ऑफ डेट क्या होता है, but every case is different, uh, and every individual has a different diseases. So it depends on the case to case basis and the prevalent rules and regulation at that time. उस basis पे उनको disability element जो होता है pension का वो मिलता है. So it's not a legal advice or so as such, but a disclaimer that it makes you a better informed uh, citizen, so that you are aware about your rights and you can go to the courts and ask for if there is any uh, due on the Union of India or the armed forces if you have served the motherland with distinction. I hope you are liking it. We'll come with the next video. I hope you like this. Jai Hind.